Good afternoon and welcome to another Clayton County Library System virtual program. Today we have Mr. Charlton Bivens, who will be talking to us about criminal records and expungement. And I am hoping that the information presented today is information and that you can actually use and apply in any situation or with any member of your family or friends that you may know. Please feel free to type your questions in the chat, and I will be sure to make sure that Mr. Bivens gets your questions. Mr. Bivens, welcome.
Thank you. Thanks for having me, Miss Oliver. I want to commend the libraries, your staff, and the library as a whole for bringing on innovative ideas, innovative information that is so vital to our community as a whole. So keep doing what you're doing. I really appreciate that, and I am just honored to be here today. I want to start. I want to start today off with a quote, and I think it's so appropriate. The quote that I've selected, and that quote is this: "Even in the game of baseball, go Braves, one strike is not an out." The topic that I want to talk to you all today is about understanding the new Jim Crow and Georgia's new criminal record restriction process. Now you're probably asking, what does Jim Crow and the civil rights movement and all of these things, what do they have to do with criminal records? Oh my God, they are really one and the same. We're going to go through that, and I hope you enjoy and can appreciate the way that I kind of put some things in perspective. My name is Charlton Bivens. Again, I'm a Clayton County resident. I am a community organizer here in Clayton County. I am retired now. I'm a second chance citizens advocate. I also am a criminal justice reformist. I stay at the state capitol fighting for those that have criminal records, fighting for those that are in and out of jail, fighting for anyone that is dealing with the law enforcement system or the criminal justice system as a whole. I am also owner of Ash Charter Consulting. Now, Ash Charter Consulting, we are a criminal record specialty company. That's all we do. We educate you. We do research, we dissect, we lobby, we advocate on your behalf to the courts, to the sheriff's offices, to the police departments, to the clerk of court's offices as it relates to criminal histories. We perform three major tasks. One is criminal record restrictions, and we're definitely going to talk about those today. The other tasks, the other activity that we deal with are criminal record sealing. Restrictions and seals are totally different. And lastly, we help our convicted citizens with the state pardon process. It's not just the federal government and clemency that you kind of see on CNN that has a pardon process. Your states have pardon processes just as well. I do want to give this disclaimer. I am honored that I am not an attorney. I'm able to say some things and do some things that attorneys can't do. So it makes me a wonderful person in that I volunteer and provide hours and hours of services from the standpoint of being just a regular Joe. And I'm kind of proud of that. Now, with all that being said, I'm actually a retired law enforcer. So I've seen the perspective from both ends of the candle. My years at DeKalb County, I have both worked in the jail and I ended my career in law enforcement, actually in the court system. So I have seen some of the injustices and some of the issues that are involved in our criminal history system. I travel around the state of Georgia quite often talking about law enforcement reform. I talk about criminal justice reform. I speak on mass incarceration. I speak on tough on crime laws. I speak on the drug laws. I speak on all of these things that are causing us to be arrested. But collectively, all of these things, mass incarceration, prison industrial complex, get tough on crimes, drug war laws. All of these things comprise of this new phenomena called the new Jim Crow. And you might have heard that. You might have heard something about the new Jim Crow over the last couple of years. You know, it's said, you can turn the next slide. It's said that I have a Harriet Tubman type of mentality. Next slide. Okay, thank you. Harriet Tubman once said, and you know, I have to laugh about it, I would have saved more slaves in my lifetime if they had known they were slaves. And it's because of that that I have no choice in my life right now than to be here today to educate and facilitate all the facts about the new Jim Crow and tie them into your criminal history and criminal record issues. You know, I call it actually the new slavery 2.0. I've always thought it was unfair that people could not repay their debt to society because of their criminal records. Yes, they could serve their time served, but that record still followed them. I've always wanted to help break the generational curse of incarcerations. Your granddaddy went to jail, your daddy went to jail, your mama went to jail, your sister and your cousins went to jail. That's not always our fault. Now, it might appear that I'm anti-law enforcement, and I'm not. I am law enforcement reform. I'm pro law enforcement reform. And there are a lot of things that need to happen. I also um, want to help the cycles of recidivism. You'll understand what recidivism is. That long word that gets your tongue tied actually is nothing more than going to jail over and over and over again. So we want to break that cycle of recidivism. You know, criminal justice should be about rehumanizing people, not dehumanizing people. So that's my story. And I'm here today, hopefully, to improve your story or to improve someone in your life's story as it relates to criminal history. Move to the next slide. Before I go any further, let's go back in time because I want to set the context. Pictures such as these are oftentimes what we remember in those Black history classes, what we remember on those movies. Well, let me give you a little quick history level. Every picture that you see on this screen right now is a form of slavery. With the exception of the first two pictures, every picture, every other picture, sharecroppers, form of slavery. Chain gangs, stripes, form of slavery. Work camps, form of slavery. Community service crews, form of slaveries. Now we have private prisons, form of slavery. Ever thought about that? Ever thought about it? Take away these first two pictures of raw slavery, and what's the common denominator in everything that's going on? Look at it. What's the common denominator in all of our modern day pictures that you see? Well, I'm going to tell you. The common denominator is incarceration. The common denominator is a negative interaction with law enforcement. And that actually is a sad statement, but it is actually also written and also very evident and has been carried out through the years. All right, here we go. Black History 101. Black History 101. From 1619 to 1863, about 244 years, we were in slavery. And I hope I can speak candidly and freely. And let me just go there with you. When I say we're speaking of slavery, I'm speaking of speaking of field niggas. I'm speaking of house niggas. I'm speaking of castrations. I'm speaking of rapes. I'm speaking of families being separated, all in the name of slavery. Now, I'm going somewhere with this. It was not until the Emancipation Proclamation came that we became free. So, we became free by way of the 13th Amendment You're going to hear that again. The 13th Amendment. Keep that in mind. 13th Amendment. 13, 13, 13. You got to keep that. But our actual day of being free was January 1st, 1963. Yes, we typically celebrate Juneteenth, 1965, June 19th, 1965. But our actual day was January the 1st, 1963. So we were freed in 1865. Guess what happened in 1866? In 1866, a concept called the Black Code Laws came about. The Black Code Laws came about whereby black inmates were locked up and then leased out to sharecroppers to work their sentences down. Now, I'm going to go back to that. We were freed in 1865. 1 year later, all of a sudden, there were these laws, criminal justice laws, that re-incarcerated us. Let me tell you how bad it was. Black code laws incarcerated black people for being homeless. They called it vagrancy laws. Black code laws incarcerated us for loitering. You put us off the plantation. We have no home. We have no base. We have no choice but to jump from place to place. Incarceration. Black code laws incarcerated us for a term called job abandonment. So guess what? You say if you were lucky enough to get a job, you actually could lose that job if you called out sick. They called it job abandonment. Black code laws incarcerated us for being unemployed. They called it job contract violations. And last but not least, and there are so many other examples, black code laws actually locked us up also if the sun went down and you were still on the streets. Now, as senseless as this is, there's a purpose behind that. And we're going to get to remember Amendment 13, the 13th Amendment. So now, 1866 to 1889, we experienced black code laws. We experienced all types of inequities in our life. 50 years. 1889, here comes 1890. 1890, we got free again. 1890, the 14th and 15th Amendment kicked in. The 14th Amendment being equal justice, equal protection under the law, and the 15th Amendment was the right to vote. So we had a little period of freedom from 1890 to 1940. But guess what? Early 1940s, Jim Crow laws kicked in. What did they do? They senselessly locked up black people again. I'm going somewhere with this. Criminal records, the laws, and the history of black people, and as it relates to laws. 1890 to 1840, we were free under equal protection laws. 1940, 1960, we had Jim Crow laws, very much like black code laws, ridiculous laws. I wish I had young people on this set today to explain just how ridiculous some laws are that got us locked up and put us back in a semi-slavery mode. You ever heard the term reckless eyeballing? Reckless eyeballing is actually still on the books today. Reckless eyeballing is if a black man looked at a white woman, he was arrested. It gets worse than that. You ever heard of sidewalk bumptious law? Sidewalk bumptious law said if a white couple or a white woman or white male was walking down the sidewalk, for the fear of bumping into that white woman or white man or couple, black folks used to cross the street. You were arrested because of that. There was even and ladies, you all can contest to this. There was even a buy, not try law. If you went into Macy's or Dillard's or Rich's, you could not try on in that dress or those pair of jeans. You could not try them on. It was against the law, and people were locked up for these ridiculous laws. The last one, which I thought was extremely sickening, is a pull up to the bumper law. If you were fortunate enough to have a car You had to remain 8 feet away from the bumper of the white car owner in front of you or the white car owner behind you. But all of these laws were put in place. Why? To incarcerate the Black population. Because once the Black population was incarcerated, then free labor, quasi slavery type labor, could occur. As of the 1960s, you still had that going on. So let's move on. So 1960, then came Brother Martin Luther King and the Civil Rights Movement. So we had a period of freedom again, 1960 to 1970. Well, guess what? Early 1970s, Ronald Reagan, president, Bush, president, initiated being tough on crime and created reasons to lock up Black people. War on drugs created more reasons to lock up Black people. Mass incarceration, more reasons to lock up Black people. Prison industrial complex, where you bring people in prison, those that go to prison, then you put them to work in manufacturing companies to create products. Another reason, another way to lock up Black people and put them to work. Collectively, those four techniques or those four tactics of incarceration of mostly Black and brown people were for, or is now called, the new Jim Crow. The new Jim Crow consists of mass incarceration, consists of tough on crime laws, and consists of the war on drugs, consists of the new the prison industrial complex. Well, guess what? There now is a fifth tactic of incarceration, or a fifth tactic of bringing the Black race down. Ava DuVernay made a wonderful documentary called 13, and you probably see it on the screen. 13 is a great movie. It gives what I'm speaking of in so many more details. And once again, Michelle Alexander, also a civil rights attorney, wrote a book called The New Jim Crow, where she went into detail on that. The sad part about the fifth tactic is that it wasn't a jail situation. The fifth tactic was called collateral consequences of having a criminal record. And what I mean when I say having collateral consequences of a criminal record, this nation said, well, we can't keep all Black folks in jail all the time or forever. Then no problem. What we'll do is we will make their record penalized and follow them for life. We can control the Black and the poor by virtue of creating criminal records for them so that they cannot succeed or cannot have the success that is given to Americans as they should. So now you understand my labor of love. That's the end of my Black history lesson. But I brought this up to the degree of letting you know that all of the oppressive ways have come into contact now in our modern days to create a situation that's not really good for Black and brown people such as you and I. You can turn the next one.
Question.
Yes, ma'am.
So I have two questions that has been posted. The first one being, isn't loitering still unlawful? And the second question is, how many of the laws that you mentioned still exist?
Loitering is still a crime, but loitering now is not as racially motivated as it is personal property motivated. Loitering now falls into the category of criminal trespassing, or I, the owner of this property, don't want you, the trespasser or the loiterer, on it. The second question, how many of the laws are still on the books? They are probably hundreds of them that are still on the book, believe it or not. They aren't per se acted on, but they are absolutely still there, and you're going to understand that with this next slide. Next question. All right.
Those were the only two questions.
Gotcha. Remember, I spoke of when we initially got our freedom, how it was the Emancipation Proclamation and the 13th Amendment, and hoorah, hoorah for Abraham Lincoln because he did black folks so much good. Well, guess what? No, he didn't. He absolutely didn't. The 13th Amendment reads that the 13th Amendment to the United States Constitution abolished slavery and involuntary servitude, except, except as a punishment for crime. In Congress, it was passed by the Senate, da, 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 da. I'm going to say it again. Except as punishment for crime. Now, the young lady or gentleman that asked me what laws are still in the book, well, guess what? This is still our constitutional amendment. Slavery is a accepted practice if you are convicted of a crime. I gotta say it again. Slavery, old school slavery that you saw in the first and second slide, is still acceptable and lawful if it is punishment for a crime. Now, it's unfathomable, but does it now make sense to you why when I showed you that sign, that those pictures, how everything was related to law enforcement, everything was related to incarceration, everything was related to being behind bars before they had you working? This is huge and no one will ever talk about it. You know, there's an old saying, long as this is there, we're good. Once again, if we can lock them up, black people, we can lock them down. If we can lock them down, we can keep them down. If we can keep them down, then we can work them for free and we can control. Make America great again. Where'd you hear that from? It is astounding that this type of law is still on our books. So that's a great question about other laws, but this here encompasses just what law enforcement is about. The 13th Amendment actually makes reality to slavery something very doable in 2021, 2022. Okay, right after slavery and black codes were enforced, we were locked up. Right after Reconstruction, Jim Crow laws came about and we got locked up. After the civil rights movement, the war on drugs, the mass incarceration, the tough on crime laws, the prison industrial complex laws, the criminal record, and the collateral consequences of criminal record laws are now the driving force to incarceration. You can turn. This is my history lesson for today. If this isn't making slavery 2.0 legitimate, I don't know what is. And it's such a silent and a quiet element. What are collateral consequences for criminal records? Collateral consequences for criminal records, sometimes they call it perpetual punishment, sometimes they call it invisible punishment. I don't care what you call it. Collateral consequences to a man who has a criminal record is this: it's invisible punishment to citizens that have been found innocent or guilty, and they've served their sentence, they've completed their parole or probation, and they systematically rejected, they're systematically damaged, they're systematically, legally discriminated against, and perpetually blocked from the normalities of life, liberty, property, and the pursuit of happiness, which is one of our constitutional rights. That is what collateral consequences are now. And the old version of incarceration itself, holding a people down or creating a separation of people, it's now gone to a different level. Collateral consequences of criminal histories is where we're going. Now, what does it really mean to be legally discriminated against? If you would turn it, next page. Legal discrimination. Because of collateral consequences, you can be legally discriminated from a job. I don't want to hire you and I have a legal reason. You have a record. I don't want to hire you because you've been arrested. Legal discrimination against housing. I'm so sorry, Mr. Smith. I can't let you rent my house, rent my apartment, because you have a criminal record. And you all have heard some of these. Legal discrimination against state licenses and certifications. Now, this blows me away. How in the world can you, while in prison, I pick up a trade of barbering or beautician, or I become a cosmetologist? When I get out of jail, I have to get certified to be a barber or a beautician. But guess what? My conviction will not allow the state to give me that certification. Let's sink in. In jail, I am put in the position where I pick up a trade. You give me opportunity to pick up a trade. That's a good thing. And when I get out of jail, I can't even use the trade that you gave me because of your system.
I have a question in. Question
Yes, sir.
is this only in the state of Georgia?
No, ma'am. No, ma'am or sir. This is not, this is nationally. Every state has a different criminal record theology, criminal record philosophy, but the basis of the things I'm saying to you is a national issue. It's a national issue. Legal discrimination against educational opportunities. You all have seen that star athlete mess around and go to jail one time in high school or get in trouble one time and nobody wants him. You see it every day now how contracts are lost because of you going to jail. You have legal discrimination from human services. When I say human services, you're denied. How in the world? You have a drug problem. You went to jail for drugs. You get out of jail for drugs. You've been in a drug treatment program. But because you have a felony, you can no longer go to that drug treatment program that's not affiliated with the jail. So you can't continue getting to become a better person because of that. Workforce programs, you can't get in because you have a felony. You know, I have the story. My brother actually got in some trouble, and he was mentally he had a mental disability, so he qualified for EBT, SSI, all of these federal funded. While he had a warrant out for his arrest, they cut all of his benefits. Did not care if he ate or not. Did not care if he got medical attention or not. But these are the consequences. These are the legal discriminations and legal consequences that can come about because of criminal records. You know, don't get me started on constitutional violations, because having a record, your 14th Amendment, is violated. 14th Amendment say that you should have life, liberty, property, and the pursuit of happiness under equal protection of the law. There is none. You legally are violated because your Second Amendment. If you have a felony, you cannot have a gun permit, right? Right. You are legally violating their 15th Amendment, the right to vote. Felons can't vote until they are completely through with their sentencing, which could be for years, because you might do 5 years in jail, but have a 15-year probation or parole. So that's one vote that can't go toward some very serious issues in your community. You legally violate your 13th Amendment, your right to be free from slavery. You remember the Lincoln loophole said, except if you're convicted of a crime. So slavery is still in place. Again, forced oppression, to me, this is just my opinion, is synonymous with slavery. Forced oppression is synonymous with slavery. I want to speak for just a second about backgrounds and some of the legal discriminations as it relates to jobs, as it relates to all of the different types of legal issues that will make you stand out from the crowd in a negative way. Prison and jail conviction, of course, they hurt your opportunity for employment. But guess what? Non-convictions, Lord knows we're going to talk about that in just a few. Non-convictions hurt people in their opportunity for employment more than convicted people, because non-convicted people don't even know that they have a criminal record, even though they were found innocent or charges were dropped. Incorrect criminal histories hurt your opportunity for employment. I'm a great candidate for identity fraud. Never been in trouble in my life. If my brother, let's say my brother was a street guy, sold drugs or did drugs. If my brother got arrested and told them they were Charlton Bivens, me, the legal system has no comparison because Charlton Bivens has never got in trouble. I've never been fingerprinted. I don't have a rap sheet. So if Charlton Bivens never gets in trouble, then my brother could be me legally in the system. So now here I am. The one time I do speed, I get pulled over. I get pulled over by the police, Mr. Nice Guy, Mr. Never Get in Trouble, Mr. Police Officer. If my brother has started a criminal history for me, and not because he looks like me, because he just said I'm Charlton Bivens. Now I'm wondering why the police come into my car 4 deep with guns drawn. I was just speeding, maybe. Oftentimes, incorrect criminal histories do more harm for you than anything else. We, as charter consulting, we do more corrections of criminal histories than we actually do expungements or record restrictions, where your cousin or your brother used your name when he went to jail, and now you got to undo what he's done. And it's doable. Don't get me wrong. It is doable. It is doable. Okay. Now, next page. Let's get to the nitty gritty part of criminal records. You all have seen this before, but let me give you a formal definition of what these are. You have felonies, misdemeanors, and ordinance violations. These are the ways that criminal records are started. Felony crimes are those punishable by 12 months or more. Okay? Most of your felonies you are dealing with the district attorney. That's who's going to try to prosecute you. They're fingerprintable. You hear me use that term, fingerprintable. Anything that is a felony is fingerprintable. If it's fingerprintable, you just started a criminal history. Next, you have misdemeanor charges, and those are crimes that are punishable by up to 12 months, not more, but up to 12 months. So you could go to jail for 11 months and 30 days, 11 months and 29 days. Your solicitor general is the prosecutor for those charges. They are fingerprintable. Felonies, fingerprintable. Misdemeanors, fingerprintable. Meaning when you go into a jail setting, they're going to take your fingerprints. The last type of criminal charges are ordinance violations. Those are your traffic tickets. Those are your jaywalkings. Those are some of your minor charges that some of your cities oftentimes will potentially charge you with. They are not fingerprintable. Traffic charges are not state charges. They are not part of your criminal history. Yes, you have a Department of Motor Vehicle record that says you've had 9 tickets and they take points away and all of these things. But of all charges, you want ordinances more so than misdemeanors or felonies. Now, $1 million question. When does your criminal history start? Whether it's a felony, misdemeanor, or ordinance. When do you think your criminal history starts? Let me give you the answer. It's when you're handcuffed. It's when you're handcuffed. Next slide. When you're taken into custody, whether it is supposedly for a protective element, sir, I'm gonna put these handcuffs on you because you're a little irritated. I just want to talk to you. He has to create a report that he took away your liberty or took away your freedom to move. That is called an arrest report. An arrest report is the first document that starts your collateral consequences because somebody else can see that report, and that report is damning to you or could be damning to you in the future just because of that. Believe it or not, some arrest reports sometimes are worse than guilty pleas. And I'm going to say it again. Sometimes just the fact that you got arrested is worse than a guilty plea. Why am I saying that? An arrest report is a public document. Right now, I can find out if you've been arrested 100 times. Whether or not you've been guilty or innocent in terms of your full criminal history is a little more difficult to get. So employers oftentimes never make it past the arrest report. Just the fact that he got locked up, he can't work for me. He can't live in my house. Arrest report. So your criminal history starts once they put the cuffs on you. Next slide. Any questions? All
Not
right.
at this time.
All right. Of all the situations, I guess an arrestee versus inmate, an arrestee, you have a slight opportunity to turn and go the other way. And what I mean by this is this. The police car pulls up, you in the back, and you walk into that thing called a jail or detention center. I call it a hellhole sometimes. Uh, and the door closes behind you. You are now inside of a jail, but you're still an arrestee. So of the classifications, you being just an arrestee is okay because at some point you can turn around and be released. But once you come inside of that jail, have you ever seen the "This Is It" commercial where they talk about the rib tips? You know, you gotta love the rib. The owner say it's the rib tips. Well, your criminal history actually starts when that officer says, I need your fingertips. Your criminal record all of a sudden has an identifier, and it's the tips of your fingers. That tip, my tips say Charlton Bivens more than my name says Charlton Bivens, because I can change my name to Waleed at any point in time in life. I can change my name as much as I want to legally, but I can't change this. So in the law enforcement arena, your fingertips, and that's the key to know whether or not you have a criminal history. Remember, when you get that ticket on the side of the road, that traffic ticket on the side of the road, he hands you a piece of paper. You might sign it, but he does not take your fingerprint. That is a great telltale sign that something is considered a criminal history versus it just being a violation or just being an administrative element that of a law enforcement interaction. So you become an inmate once he or she completes your fingerprint. That becomes your permanent record until you do something with me, do something with an attorney to remove that record. Documents to be concerned about. Remember, I told you that once he puts the handcuffs on you, you create an arrest report. When you go inside of the jail, the jail will create a booking report. When you stand there with your little 225 number, you create a mugshot. Your criminal history starts when you create a fingerprint card. Now, interesting thing, and you're going to hear this in a second. Your booking report is a public record. Your mugshot is a public record. Any news, and I know you all have experienced this, some celebrity gets locked up for DUI. You ever wonder how the Channel 2 News knows that T.I. was fighting his wife and he got locked up? Because it's public information. It's public information. It is still your criminal history, but it's public information. Again, your criminal history starts once your fingerprint comes. Next slide. You know, very interesting picture, and it was deliberately done. Yes, that is dung on the backside of those animals, and I think of collateral consequences of criminal histories as crap in our justice system. So that was it's meant to be kind of comical, but it's also very serious in that the rear end of our criminal history, the rear end of our justice system is crappy. Now, on the front end of our criminal justice system, you see it every day. plenty of publicity. You see on YouTube, you see on CNN, you see on Fox excessive force cases, you see wrongful shooting cases, you see illegal arrests, you see all of this, you see those things. And we are working as a people on correcting even some of the wrongs with illegal arrests and wrongful shootings and all those things. But on the rear end of the justice system, you don't see anything. You don't hear about that. The rear end of our criminal justice system occurs when everything is supposedly over. What do you mean? Well, you're in court and jurors find you guilty or not guilty. You walk out of the courtroom relieved. No, ma'am or sir. You shouldn't be relieved until you get that record still is there. And it doesn't have a big smiley face that you were not the person that did the crime. Prosecutors drop the charges in court and you walk out of there relieved. You shouldn't be. That crime is still attached to your name. You're released from jail on probation. You walk out to jail happy. You shouldn't. That crime is still following you. You're released from prison and parole and you walk out to prison thankful. The battle just starts. Or you're timed out. You've served your time and you get out of prison. Walk out and be thankful that you're free, yes. But even that situation, your problems are just beginning. There is hardly any publicity from the collateral consequences of having a criminal record. Parole doesn't tell you, by the way, you won't be able to find a job. That's a consequence of your record. Probation and parole will mandate monthly fees and won't tell you, oh, oops, you know you won't be able to pay them because you ain't going to find a job and you can't live everywhere you want to live. So you're going to end up back in jail on an administrative charge or a non-payment charge. You'll be back. And this is what we're dealing with every day. Prosecutors don't tell you that your record is still out there and it's going to haunt you from the time you walk out of that institution. I'm here to tell you it's not going until you make it gone. It's not gone. Your record is not gone until you make it gone. Our saving grace occurred in July of 2013. You can change next slide. Governor Deal signed into law the record restriction law. The record restriction law. Now, let me explain something. It was Governor Deal truly concerned about Black people and us getting criminal records taken off? I really don't think so. I believe, and this is again my thought, his social services budget was going so high that he had to find a way to put eligible, competent, capable people back to work. And as long as people had non-convictions on their record that was stopping them from getting jobs, they were going to have to continue using social services, EBT and TANF and all of these services. But I will take the fact that he did change the law, and Georgia now is one of the easiest states to get criminal records taken off. In the past, removing a criminal record was called an expungement, like a sponge. We're going to wipe it clean. It's no longer called expungement. I'm old school, so I have to catch myself. It's now called record restriction. So record restriction, the new July 1st, 2013 law, 35-3-37, the new record restriction law became the new expungement law on steroids. What is the record restriction law? The record restriction law is the process of hiding non-convictions from the public. It's a legal way to hide, and I use the word hide before I use the word remove because the record is still there. Law enforcement will forever be able to see it, but public and private employers can't see it. Your mama, your girlfriend's mom can't see it. Those things will be gone. Your record will appear to be flawless in the eyes of everybody but law enforcers. Now, I use the word non-convictions. I know you don't know what that really means. We're going to get into what all the different types of non-convictions out here. There's a very small group of convictions that you can have restricted from your record. Governor Deal, in the midst of making those laws, understood that if a little 18-year-old goes into Walmart and picks up and shoplifts a $10 bag of chips or a $10 clothing item, that 18-year old was going to have the most terrible time of their life at the most earliest time of their life going into adulthood. So he created what they call the young and dumb clause onto the record restriction law. The young and dumb clause says that if you're 18 to 21 years old and you commit that dumb mistake and it lands you in law enforcement or criminal trouble, that I'm going to relieve you. I'm going to relieve you. I'm not going to hold you to that stand. You young, you're too young to be an adult, but you're definitely not ready for but you're too old to be a juvenile. What he does, there's a very select list of misdemeanor charges that if you're convicted of, he will allow to be restricted from your record. It does not include any of the major uh, misdemeanors. It doesn't include DUI and some of the more aggravated misdemeanors. But there's a very small group, and I'll take that because in the past, no convictions, none, were ever relieved or forgiven. Now, at least, we have a small number, and legislation and lobbying from people like me, lobbying from different nonprofit groups that are about second chance citizens. We're trying to increase the number of charges for the 18 to 21 range. If you go through the record restriction process, it cannot be denied. If that arrest is supposed to come off by law, it must come off. Now, Georgia's record restriction is just limited for Georgia, but every state has some states still call it expungement, some call them record restriction, some call them whatever they want to call them. Every state does have some modifications in 2021, and we're not as antiquated, and some states are not as antiquated as they were 10 years, 20 years ago. I'll take the next slide.
Question. Okay, so we have a question. This individual is asking, can failure to show up in court result in a criminal record as well?
Yes, it can. Failure to show up in court can turn into an actual warrant. Remember, every time you are summoned to go to jail, whether you're on bond, coming out of jail and you go on bond, you are signing a legal document or a legal contract that you will show up for court. When you don't show up for court, you have violated that legal document, that promissory note that you'll come back to court. And that's actually a violation of the law. You know, bonds don't have to occur. And when you are granted a bond, that is a contract, and you violate that contract when you don't show up to court. Any other questions?
Not at this time.
All right. So now we have talked about what the record restriction expungement is. We have talked about collateral consequences of having a criminal record. Now let's talk a little bit about what rubber meets the road. What can an employer see? Well, number one, let's start off here. Employers must tell you that they're checking your background, what they found, and the effect it has on their hiring process. Now, can they tell you, I'm so sorry, sir, I hired Mr. Smith? They can. But legally, if you feel that you've been discriminated against, you absolutely know you're the better person, they have to let you know that I didn't hire you, because they still don't have to hire you, but they have to let you know that this is what we found, and based on that, we're going in a different direction. All right. Right now, I call it the nosy neighbor check. You can go to the police station on any given day and get a felony convictions check on. All you need is their name. You're able to do that, but all you're going to get is a felony conviction. So they might have been in jail 25 times, some of them misdemeanor charges. An employer can do the same thing. He has the right. You've filled out an application. He has Charlton Bivens on the application. He can go and pay to get a felony convictions background check. It's not a complete check, and they rarely do that because they realize there are other little things that could pop up in a person's life. So that is what an employee can do. When an employer has your consent during the application process, oftentimes they will say, we run a background check. Your employment is contingent on us pulling a background check for you. With your consent, you may get an employer can get a background check on you of all of your criminal history record information. An employer with your consent can also get private company criminal record history information. And with your consent, he can also get public criminal record information. It doesn't take his consent for public, and we're going to talk about that as well, but he has the right to do that with your consent. Okay, you can turn it. Let's talk about the three types of criminal records. You have official reporting, unofficial reporting, and then you have public criminal history. Official criminal history is you hear the term GCIC, or the GBI has my criminal records in GCIC. That's Georgia Criminal Information Center. NCIC is National Criminal Information Center. That's that database that the police or the sheriff or your marshals have. The GBI manages this information. It is your official criminal history. So now that's the most efficient, and the most official rather. Next, you have private companies. You have private companies like Truth Finder, Been Verified, Checkmate, People Look Up, US Search, People Looker, or just Google. You have private companies that do the same thing that the GBI does. But this is the catch. It's not official, number one, and it's definitely not editable. And when I say editable, they don't update it. Private companies at the beginning of each year, they go and buy a criminal record disc, and they have the right to do it. They are slated to be official and authentic. Well, they will buy a criminal history disc that has everybody in the state of Georgia on this database. The catch is this: if I get my records expunged, or if you have records on me and I win the case in the GBI system, in the GCI system, those records can be changed. They can be restricted. They can be whatever. In the private company business, you're stuck. If you were charged with murder and you beat the case in February, that charge of murder will not come off your record to the following year, or whenever they get the next set of database or the next disc of criminal information. And I have to give that I have to tell you about those two, because both are being used against you in employment and housing and all of the different consequences and all of the different ranges of consequences that are coming against us. So the most official is your GCIC criminal history, but understand that you do have private companies that have your criminal history, and employers will sometimes use private companies and won't use the official, and they will get you, or they will find and see things on your record because they don't have the ability to update and to change. Now, the third type of criminal history is called public criminal history. Right now, if you all got your phone now, you got your phone, right? On your phone, right now, if you know someone's name You can go to Clayton County Sheriff's Office, Fulton County Sheriff's Office, whatever county sheriff's office. Every sheriff's office has an inmate directory, and this is crucial information. You can pull up anybody that has walked through the doors. Remember, I talked about a booking report is criminal history, a mug shot is criminal history, an arrest report is criminal history. With your phone now, if your nephew, curious if your nephew ever got locked up here in Clayton County, you're able to go to Victor Hill's directory on his website, his online website. Matter of fact, I have his information. ClaytonCounty.ga.gov/government/inmate search. On that, on the typical sheriff's office website, you can find out if Mr. Smith has ever been arrested. I didn't say convicted, arrested. That is called a public record. Now, the other form of public record, if you don't want to use your phone and sit where you are and pull that public record, if you want to do just a little bit of work, you can ride down to the courthouse and go to the state courts clerk of court's office, or go to superior court's clerk of court office. Inside of the clerk of court's office, in everybody's jurisdiction, in everybody's county, they have computers in the back where you're able to look up information. It's public information. You put my name, Charlton Bivens, in that computer. If I've ever been in a courtroom, whether it was a civil charge or a criminal charge, it's going to be on that computer. It's going to be on that computer. Now, why am I telling you this? This is why I'm telling you. Oftentimes, employers, homeowners, or people with properties, they won't pay $45, $50 to get a official background check from the GBI. They won't pay those fees to pull your real criminal history. What they'll do, they'll tell their secretary, "Hey, pull up Mr. Bivens. He lives in Clayton County. He might have been locked up in Clayton County before. Matter of fact, go with all of the neighboring county. Go Clayton, and then go Henry, go Fayette, go DeKalb, and go Fulton County. Look on their sheriff's office inmate directory. See if he's ever been there. If he's been there, I can't hire him." And that's oftentimes how we're discriminated against without them ever seeing that you beat the case. The case ain't supposed to be there. They will take the fact that you've been in somebody's jail and discriminate against you that way. They will take you in somebody's courtroom for this horrendous charge that you beat and use that against you. So we got the official criminal record with GBI, unofficial criminal record with private companies, and then you have public criminal records with clerk of court's offices and the jails. Any questions? All right, next page. And we kind of went over this earlier. As I said, court records are always stored in the clerk of court's office, and it's public record. You walk up, you put a name in, and there the information is. The jail mug shots are there. The jail inmate dockets or directories are on everybody's online course. Those are these three forms here get more people, get more people either fired or not employed than the actual criminal record. All right, let's move on. Any questions? All right, let's talk about how we can solve criminal record problems. Now, all charges are not restrictable. There are three methods that we use, or three methods that are here. The first is called record restriction. Second is called sealing. And third is the pardon process. Record restriction in and of itself is for non-convictions. And we talked about the only form of convictions that do fall under record restrictions or expungements are the 18 to 21 young and dumb clause type of misdemeanor charges. So The record restriction process is the only savior that a person has to remove information about them that does not belong. If you were not found guilty, nothing about that incident should ever be there. All the way up from mugshot, arrest report, booking report, court paperwork, final disposition. All of that information shouldn't be there. And that's what the record restriction process does. Any questions about that? So record restriction gets the official record off of your record. Sealing of records. Remember I talked about public records and I talked about your mugshot. I spoke of your inmate directory or the fact your booking report. I spoke of your clerk of court, the fact that you've been in someone's courtroom. You are able to seal public records. Official records have to be restricted. Your public records have to be sealed. What do I mean in layman terms? If you are found innocent of a charge, it is incumbent upon you to have that record restricted from the courts off of the official record. Because those records are in the courthouse at the jail, if I get a record restriction order from a judge for you or from a prosecutor for you, I can take that and convert it to a sealed order. I can walk in Victor Hill's office or the sheriff of your county with a court order that says you have Mr. Charlton Bivens mugshot and information that he came in this jail. Take it away. Take it off. Take it off your computer system. Take it off your file. It cannot be public record. They have to honor that court order for seal. I take that same court order of a seal to the clerk of court's office and tell that clerk of court, remove anything on this computer that has Charlton Bivens' name. They have to comply with that order. Seals and record restrictions are two different things. You restrict your official record, you seal your public record. And I want to make that clear. Oftentimes people say, yeah, I'm going to get my record sealed. Well, it doesn't work exactly that way. If I'm able to restrict your record, then I can seal it, but they're totally two different processes. Super easy, but they're two different processes. The third solution to criminal record consequences, and I use this as a solution. Well, understand where I'm about to go. Pardons are beneficial, pardons are important, but pardons don't, I'll say it again, pardons don't remove the information from anybody's database. What a pardon does, if you've been convicted of a crime, you've served your time, 5 years have gone by, you've had no negative interaction with law enforcement, you're eligible for a pardon. I will tell you that a pardon, for the most part, is nothing but a autobiography that, yes, 10 years ago, I made this mistake and I did this. I got sentenced. I served my time. I'm now a productive citizen. I'm married. I'm a part of a church. I'm doing great things. I want to get a better job. I would love to have a pardon. It might help me get a better job. That's what a pardon is. It is a huge document where you're telling your story. And you'd be surprised at how many people can't have great stories, but can't tell that story in a way, in such a way that Board of Pardons and Parole Board will understand that, you know what? I think he's learned this lesson and he's doing so many productive things in the world. Now, that pardon does this for you. This governor and the Board of Pardon and Parole seal goes on your criminal, they stamp your criminal history so that anybody that looks at your criminal history will see, number one, that the governor thought enough of you to say that you are restored and back to normal. The Board of Pardon and Parole has a seal stamped on this document stating that they have faith and they have confidence in you, and they hope that because those two major entities have confidence in you, that that employer or that homeowner or that landlord will have confidence and give you that second chance, as we say. So a pardon does not remove the record, but it will give a seal of approval, kind of, sort of, on you, your lifestyle, and your record. Most of the time, when I get pardon opportunities, it's for restoration of rights. A lot of people have charges that do not withhold their opportunity to possess a firearm. So pardons, for the most part, so far in my career, have gone toward people that had minor to middle level crimes where they were able to carry a firearm if they could get a pardon. All right. Any questions?
None.
All right. You take the next one. Record restrictions versus sealed. And we kind of talked about this a little earlier. Remember, record restrictions kills whatever information is on the GCIC report. Court files still are available. So you went to court, you went to jail, you were arrested, you went to jail, you bonded out, you went to court, there was a disposition, either you were found innocent, or you were probated, put on probation, or you served time. All of that information can be restricted. But the fact that you dealt with the jail, the fact that you dealt with the court system, those records, and those records won't have a conviction or an innocent element to them. It just shows that you were in jail. It just shows your mugshot. It just shows that you were in somebody's courtroom for something, and it does show what that was for. It definitely doesn't show a disposition or what occurred after that. Those are the elements that you want to get sealed. So that's a huge thing. I highly recommend that not only you get your records restricted, but you also get those records sealed. Because in not getting them sealed, that employer who doesn't pay for the restriction and the background check will have his little clerk, he'll have his little secretary call down to the courthouse or go down to the courthouse or pull up information online and get bad information about a good person. Okay, next one. Now let's talk about non-convictions, and this might get a little tricky on you. All right, what are non-convictions? Well, let's go. Here we go. We're gonna go down this list. No formal charges. And I know you're like, man, what do you mean? Okay, let's say you walk in while black, you are questioned, you're arrested, you get fingerprinted. Then 4 hours later, they realize that it was Willie, it wasn't you. They let you go. They let you go. Well, guess what? Remember I said arrest report, booking report, fingerprint card, mugshot now exists. They let you go out the back door. I mean, you went in jail 4 hours. They let you go. But in that time, you created a 4-document criminal history. So if you pulled your record 6 months later after that misunderstanding, that mistaken identity, you have no formal charges, but you have a criminal history because you did that. That is a non-conviction. That will hurt you in the long run. That is a record restrictable charge. That is a record restrictable situation. Dismissed and no prost is the second one. You are arrested, you go to jail, you go to court. In court, your case is dismissed for lack of information, lack of evidence, lack of whatever, or your case is null pros. Null pros is a Latin word for not processed. Plain and simple, not processed. The solicitor or the DA says, I ain't got enough, I don't feel good about going forward, and it's another word for dropping the case. They didn't have enough evidence. That's a non-conviction. Now, do not confuse nolo contendere. You all have been probably you might have been to traffic court and was asked to plead nolo contendere. Nolo contendere is you're pleading guilty, and it's Latin for have mercy on me, judge, have mercy on me. I'm guilty, but have mercy on me. It actually is Latin for that. So nol pros means not prosecuted. Nolo, and a lot of people use that word, nolo contendere means I'm guilty, and it goes down as a guilty charge. But just have mercy on me, judge. Don't hit me with everything. So, no pros is a non-conviction. It can come off your record. MPGJ. MPGJ is not presented to grand jury. You went to jail, you got out of jail, you went to court, it almost went to a jury. The jury said they don't have enough evidence to go forward. You walk out of the courtroom, you're happy. Don't be, because that charge and all of that information is still there. That can come off your record. No bill. No bill. They try your case. The jury come out and say, y'all didn't, this man is basically innocent. No bill. That can come off your record. If you go to court, you're arrested, you go to court, and you get assigned to one of the accountability courts. You get assigned to a drug court, or mental health court, a veterans court, a family violence court. When and if you complete all of the requirements of those different courts, that record comes off. The judge told you, I will let you go to these court systems or these specialty courts and do away with your criminal history. You're not a criminal. You need some mental health work. You're not a batterer. You need family violence court to make you a better father, make you a better husband. Those charges, if they comply with all to the letter of the law, all of those. Conditional discharges, similar to accountability courts. Conditional discharge, I will sentence you to 20 days if you do XYZ. Those charges can come off your record. Acquittals, and basically that's being found innocent, come off your court. But you have to initiate it. The term dead docket, and those that are listening to this, you understand dead docketing was a way to, how was it told? How was it told to me? Was a way to build a case on people. Oftentimes, police or law enforcement have arrested very minor drug dealers or those selling drugs, but yet and still won't have enough to really get that drug dealer off the street. So they will lock him up the first time for just having a little bit of drugs. They'll dead docket that case, knowing that he's gonna do it again. He does it again. They dead docket the second one. Third time he does it, it's what did it say? Your past comes back to haunt you. Now he presents all three cases. He ain't learned his lesson. He's been locked up 3 times. That's dead docketing. If they make a prosecutor prosecute you, if he lays it to the side until you do something else, while it's being laid to the side, it should not be there. Because while that charge is laid to the side, that's the very time you're going to have that dream job you wanted. And that dream employee, you're going to see that charge laid to the side, doing nothing, not being, it's just sitting there and can sit there for years if you don't know that it doesn't have to and shouldn't be there. Either prosecute me or leave me alone or let me go. So dead docketing, if you are in a situation where you've had a charge and you're scratching your head, well, they never called me. They never sent a letter out and told me when my court date. They just told me, don't worry about it. Don't worry about it. No, if you lock me up officially, you got to close this out. And if it's not closed out, then it's potentially dead docketed or time expired. We go on that next. So dead docket is a case that's been set to the side, but it can still hurt you because somebody else can see it and make a decision about you or discriminate against you because that criminal history is there. Time expired, same thing. After 2 years, a misdemeanor charge should be tried. If it ain't tried in 2 years, you have the right to tell them, take it off of there. After 4 years, your typical and mild felonies should be tried. You should be tried for whatever case they got in 4 years. If it's not, take it off there. After 7 years, 7 years for serious felonies, serious felonies. If you don't have enough evidence after 7 years, take it off there. Time expired cases are eligible for record restriction. The next category will be reversed or vacated charges. That's kind of self-explanatory. If you've gone through the appeal process and won your appeal, then guess what? You're an innocent man. You're innocent to proving guilty. You weren't able to prove me guilty, or you proved me guilty. I came back with more information. You reversed or vacated the charges. Why are they still there? Take them off. Restrict them. Youthful offender, we talked about that. This is the only category of convictions. With youthful offender, if you commit some misdemeanor charge between the ages of 18 and 21, you've had 5 years of no more law enforcement trouble, you are eligible to have those certain misdemeanor charges taken off your record. The next category, fugitive from justice. If you committed a crime in Alabama and you absconded from Alabama and came to Georgia, well, you actually hadn't done nothing in Georgia. But you get locked up, you get pulled over, and they, whoa, I got a fugitive from justice warrant for you you wanted in Alabama. Well, because I'm gonna end up having to lock you up, I'm gonna end up having to do an arrest report, I'm gonna end up taking you to a jail, I'm gonna call Alabama. Alabama, I got a guy that you all say escaped from Alabama or supposed to be in Alabama standing trial. We got him here. Well, fugitive justice, you can have that removed because you really haven't done anything in the state of Georgia. You hadn't committed a crime in Georgia. We caught you in Georgia. And because we caught you administratively, we created a case and all this paperwork for you. But because that fugitive from justice from another state, those charges can be restricted. Felonies dismissed but unrelated misdemeanor convictions. Let me give you a quick example of that and how those charges. If you were charged with robbery is typically you have a weapon of destruction at someone and you steal something from them. If you're in a group of about 5 and you just standing there, you're going to get charged with robbery. But if you can prove that you had nothing to do with it, didn't realize your buddies were going to rob that place, it potentially can get reduced down to a misdemeanor charge of reckless conduct or something. Oftentimes, those charges can be dismissed. The felony charge that you originally were charged with, robbery versus being in the wrong place at the wrong time, is a big difference to an employer, to a person that owns a home, or some of the reasons that we're being discriminated against. So those charges. The last one, which I think is very interesting, is retroactive first offender. If you don't understand, everybody has the right to evoke their first offender rights. The first legal encounter you have with law enforcers, you have the right to go through the first offender program, meaning it not count against you. You shoplift at 22 years old, first time ever getting in trouble. You can evoke your first offender, whereas you go into community service, you take these classes, you do whatever the judge wants you to do. He gives you a 1 free pass, and that's what the first offender program is about. You get 1 free pass for your first offense against the laws of the land. Well, back in our civil rights days, Lord knows back before then, but from 70s up into present, oftentimes judges and prosecutors and actually attorneys would not ask my client, I want to file a first offender for him. So if you've never been offered a first offender for your first offense, you can get whatever charges were a part of your first offense when you were not offered first offender, you can get those charges restricted because you've been slightly discriminated against in courts. by both the judge, the prosecutor, and potentially your own attorney, because he should have known to at least inquire about first offender, or it should be documented that you didn't want to use it, and who wouldn't want to use a free get out of jail card for the first time. So those are the types of charges or the types of circumstances that you can get your records restricted from. You know, I stood in the courtrooms for years uh, as a law enforcer, and I actually saw people walk out of the courtrooms. I saw more no pros situation. We talked about the second one, no pros. I saw more of those. I saw more dead docket situations as I stood and supervised my officers than every other case. Seems like 70% of court cases end in a null pros. And they walk out of there and don't realize that charge is still on them. That charge is still on them. All right, we can go to the next slide. Any questions?
None.
Well, that basically wraps up today's presentation. We've gone from Jim Crow laws to the new Jim Crow, and just the fact that our present day law includes the fact that if a person is incarcerated, they can still be subjected to slavery. And slavery now is in the form of free work sources, and free work opportunity, not I won't say opportunity, but free work mandates uh, have always been in this society, and against black and brown people like myself. Um, I am just torn and dedicated to trying to let people know that these criminal records are there, and they're for real, and they're stopping the successes of people. And you stop a man, you stop his family, you stop that community, you wonder why there's a downgrade in society. So I'm here for those that need to speak with me later. I'm here for those that want to go even further in the conversation of getting criminal records removed. Remember, yes, this is a business for me, but it is something that you can do yourself. Don't be afraid of five-syllable words and attorney and judges and clerks and solicitors, and don't be afraid of them. The process is of super simple. I have to say I'm very impressed with the state of Georgia when they created the record restriction law, because they made it easy for us to do. They made it easy for us to do, and it's not prohibitive on you getting a high priced lawyer. If you can read, you can go through this process, and only you know your personal situations and personal circumstances. If I can be of any assistance, feel free to call me at any time. Consultations over the phone. I can let you know if you kind of in if you kind of qualify, or I definitely can let you know if we need to go to pardon process. Those that I can't restrict their records, I oftentimes want to start the pardon process if they've met that 5-year gap. I want to start that for them. It doesn't hurt. It doesn't hurt. It's not an arm and a leg to go through the pardon, because I want to see the success of all people.
Okay, I thank you, Mr. Bivens. That was a wealth of information. I am in the process, it disappeared on me. But for those of you who are online listening, whether it's via YouTube or you're here with us on Zoom, um, and I'm trying to pull it back up, it disappeared on me. But our library system has a database called Galileo, where patrons, library card holders, I think I might be able to pull it up, library card holders are able to get access to the Gale legal forms, where we have Expungement Handbook, and I think I am pulling it up. Give me 1 second. Okay, here it is. So I am going to share my screen so you guys can see what it is that I'm speaking about. Okay, can you see that, Mr. Bivens?
I can.
Okay, great. And hopefully the audience will be able to see it as well. But again, for those of you who are viewing this, Clayton County Library System has a database called Galileo. In there, we do have the Gale legal forms. And if you type in expungement, there is a host of different information in there, to include an expungement handbook that you can actually download for free, and some forms that are available for you to fill out if necessary. Again, Mr. Bivens has given you his contact information, but we also have these resources. So we thank you for joining us, and we invite you back to other online virtual programs. Thank you, Mr. Bivens.
Thank you.